You don't know what their reason for not paying the rent is until you send them the 15-day notice. If they respond with the declaration, even now, you can't evict them if they have been paying the 25% all along. Let's say they haven't been paying the 25%. Well, now you can evict them, but you first got to start with the 15-day notice. This is for any back rent owed before October 1st. Well, what if they don't pay the rent on October 1st? You can evict them. Doesn't matter what their reason is. Doesn't matter if they have a COVID reason or not. You can evict them. Absolutely, if they don't pay rent starting October 1st. So maybe you're gonna have some tenants who still owe you back rent for last year, and now they didn't pay in October either. You'd actually have to send them 2 different notices to evict them, if you see what I'm saying. The notice you have to give them if they don't pay the rent after October 1st, well, great, I just sent them the old 3-day notice, right? No. For the next 6 months, even for tenants who don't pay rent after October 1st, you got to send them a special 3-day notice. It's called the PRQ CRP. I'll put it in the chat. So in other words, to repeat, just make sure you got it. For people who owe you rent prior to October 1st, right? Prior to October 1st, then you have to give them the 15-day form. You still got to give them the 15-day. It's called I'll put it in the chat, the name of the form, the PRQ dash TP, which stands for transition period 3, because it's the 3rd version of that form. Okay, but let's say they don't owe you, they don't pay the rent starting October 1st. Well, they have no excuse, whether they have COVID or not, you can evict them. But for the next 6 months, to evict someone for non-payment of rent in residential property, there's a 3-day notice you got to give them. There's a 3-day. It's not the normal 3-day. It's the PRQ CRP. Okay. So 2 different forms. You know why you got to do this? Because for the next 6 months, in order to evict someone for non-payment of rent, you have to prove that you applied for rental assistance. Maybe you didn't get it. Maybe you're not eligible for it, but you're gonna have to sign an affidavit saying you tried. So this form, the PRQ CRP, is basically telling the tenant, for the next 6 months, the landlord can't evict you unless you apply for rental assistance and get rejected. If you get the rental assistance, you can't evict the tenant for not paying. You can't double dip. If they owe you money and they pay you, and you get rental assistance covering it, you can't evict them for not paying that rent. Okay. So 6 months from now, that's when we go back to totally normal with the regular 3-day pay rent or quit. But for the next 6 months, if they owe you money prior to October 1st, you first got to give them the PRQ TP3, which is a 15-day notice. And if they don't pay you after the 1st, it's a different notice. How do I apply for rental assistance? I hope you all, I'll put it in the website. So you got to do it, right? Because if you don't do it, you're never going to be able to evict this person, at least for the next 6 months. So there's a website, housingiskey.com. You look up your city or your county, it'll walk you through how to apply for the money. The money is there. There is plenty of money there. So if you're a landlord with a tenant's behind in their rent for COVID reasons, then
that's upsetting, Victoria.
Now, what about this?
Get it done.
Starting now, you can't not pay rent because of COVID. But you know what? If I'm a tenant having trouble, I can still apply for the rental assistance. Isn't that crazy? So in other words, I can apply for the rental assistance saying I have a COVID reason I'm not paying rent, and they can get the money. But if they don't get the money, you can evict them. You see what I'm saying? I mean, in other words, it's not up until October 1st, it was an excuse. You couldn't evict them if they had a COVID reason. Now you can certainly evict them, but until that money runs out, people can apply for the rental assistance. And if it's still there, and it is still there, they can get that money. So it's still not normal for the next 6 months, okay? It's still not normal. At least the good news is, as far as just cause is concerned, evicting people, we're back to where we were pre-COVID. But as far as non-payment of rent for the next 6 months, still a little bit different, a little bit complicated, and you got to deal with it. Now, one more thing. What if the tenant's been paying the 20, you have a COVID tenant, they were paying the 25%, but they weren't paying the other 75%. That you can now, starting November 1st, you can sue them for the back rent. And you can even sue them in small claims court, right? You can sue them in small claims court, even if they owe you more than $10,000. But you know what I'm about to say. To maintain that lawsuit, you're going to have to sign an affidavit saying you applied for rental assistance first. So to evict or to sue for the back rent, you got to first apply for rental assistance. And you know what? Why not apply for rental assistance? The money is there. You're going to get the money. The only time you're not going to get the money is if the tenant's income is more than 80% of the county median income for a household of their size. And that's the case, you won't get it, and then you'll have to sue for the back rent. Okay? But either way, you're going to have to sign an affidavit saying, I did apply for the back rent. Okay? Patty's asking me a question. What if the landlord got rental assistance, but they're paying partial rent? I'm not sure what you're saying, Patty. You're saying the tenant and the landlord have agreed they're paying partial rent. I mean, starting October 1st, they got to pay 100%. If they don't pay 100% of the rent, you can evict them. But the way you're going to do this is first you're going to give them this new 3-day PRQ CRP. And then once to file the unlawful detainer, you'll have to prove that you did apply for the rental assistance. Now, if you're saying they applied for the rental assistance for everything up until the end of September, great. They still got to file this form, but they're going to be easy to proceed with the eviction after that. Okay? Because obviously you really only have to apply for the rental assistance prior to October 1st. I did say that tenants can continue to apply on their own for rental assistance after October 1st if they want to. So it's question. Cecilia, so if you have a tenant who just does not pay, even though they don't have COVID reason, you still got to give them the new 3-day notice for the next 6 months. And obviously, basically, you're still going to have to show that you tried to get rental assistance. You're not going to get rental assistance because they didn't have a COVID reason for not paying, but you still got to go through the motions. You're going to have to sign an affidavit. You know what I say? If you're trying to evict someone now, hire an eviction company. It's too complicated, but basically, that's the way it goes. All right, enough on that. Let's stay with rentals for a second. People keep asking me the question, can I raise someone's rent? Of course you can raise someone's rent. There's no restrictions on raising rent in general, unless you're in a city like I am in Los Angeles, where there's a rent freeze. If there's no rent freeze, you can raise rent, but there are limits on how much you can raise the rent. What's the limit? Well, the limit is, it depends on if you're under California rent control or not under California rent control. If I'm under California rent control, what does that mean? In other words, it's a building older than 15 years. Well, in that case, I can only raise it by 5% plus inflation. What is the inflation rate right now for raising rent right now? Well, in your area, if you're in San Francisco, Alameda, Contra Costa, Marin, or San Mateo County, it's 3.8. Everywhere else in Northern California, it's 4.0. So if you're not in one of those counties I just mentioned, then 5% plus 9% is how much you can raise the rent. What if you say, great, I'm in a single family home, I'm in a newer apartment building, I'm not limited, right? I can raise the rent by whatever I want, right? Not so fast. Believe it or not, when your county is under a state of emergency, city, state, or national, then the anti-rent gouging laws kick in, and that limits you to 10%. So even if you're not under California rent, so if you're, in other words, you guys who I'm talking to in the where you are, unless you're in, I don't know what county you're in. San Francisco, Alameda, Contra Costa, Marin, San Mateo, its maximum is 8.8. Anywhere else in Northern California, it's 9.0. But even if you're, and that's assuming you're under California rent control, but even if you're not under California rent control, it's 10. You know why? Because the entire state of California is still under the nationwide state of emergency due to COVID. So nobody can raise the rent more than 10%. Okay? That's going to end one of these days, I hope, in which case you'll be able to raise your rent 100% if you're not under California rent control. Okay? All right. What else is going on? Let me talk about one sort of significant new law that's happened in July, and then I'll talk about new laws that the governor just signed. Okay? The most complicated and sort of annoying law that was signed, that took effect in July, is this fire hardening and defensible space. And it's caused a lot of confusion. And the reason it's caused, first of all, it's just a confusing, poorly written law. But another reason it's caused some confusion is because the CAL FIRE, the state agency responsible for administering this law, has put some misleading information out. Now, we've talked to them and they sort of said, yeah, you're right. And they've changed some of their information they put out there. It's still a little misleading, so we're still talking to them. But here's the basic deal. The way to look at it is we have a new disclosure form. People always ask me, Gov, what are the mandatory disclosures I have to do? You know what I always say up until this? I said there are 4 big ones and a couple of little ones. What are the big ones? Well, you know, you've got the TDS, transfer disclosure, you got the NHD report, you got the seller property questionnaire, and you got the lead paint form, right? If it's pre-78, the big 4, TDS, NHD, SPQ, and lead paint. And if you're exempt from a TDS because you're a probate, REO, bankruptcy, or trust sale, you're also exempt from the SPQ, and you replace that with the exempt seller disclosure, the ESD. What are the little disclosures? Oh, that's the earthquake booklet and the environmental hazards booklet and the qualified substitute form. They're not, why do I call them little ones? Because they don't give the buyer a 5-day right to counsel. I mean, you're supposed to do them. If you don't do them, it's not, you know, it's not a critical thing, but they are mandatory. So you should always do the qualified substitute for FERPTA. You should always give them the earthquake book and the environmental hazards booklet. But if you don't do it or you're late, it doesn't give the buyer a 5-day right to cancel. The 4 big disclosures that give the buyer the 5-day right to cancel are the ones I just said, the TDS, the NHD report, the SPQ, seller property questionnaire, and the lead paint form if it's pre-78. And remember, the only way you can get rid of that 5-day right of rescission for the buyer is to give those 4 forms to the buyer, make them sign them before they actually sign the offer, which does happen, I know, in some places in the Bay Area. Anyway, the point is we now have a 5th big form. This is a big form like the other 4 because it does give the buyer a 5-day right to cancel. Okay? So it's a form called the FHDS, Fire Hardening Defensible Space, FHDS. Unlike the other forms I mentioned, though, it's only required if you're in a high or very high fire zone. All of us that live in California, there's 4 possibilities. I'm either not in a fire zone, I'm in a moderate fire zone, I'm in a high fire zone, or I'm in a very high fire zone. This form is only required in the last 2, high or very high. Right? So every time you take a listing now on residential 1 to 4, you got to figure out what zone you're in. If you're in a high or very high, then you know the form's required. If you're in a moderate or no zone, it's not required. Well, how do I know what zone I'm in? You could look on your own at the CAL FIRE maps. We have a Q&A on this topic, which you can go to and just link to it. I prefer just go to the NHD company and make them tell you what type of zone they're in. Gets a little complicated because remember they have this report that they give you that shows 2 fire zones. One says very high fire zone, one says wildland fire area. If neither box is checked, you're not in a high or very high, you're not in a fire zone. So you don't need this form. If the very high box is checked, you're in a very high zone, whether it's in a state responsibility or a local responsibility, you're in a very high fire zone, the form is required. What if the very high is not checked, but the wildland fire box is checked? What is that telling you? That is telling you that you're in a state responsibility area and you're either in a moderate or a high fire zone. But of course, I just told you this form is only required if you're in a high. So how do I know which one I'm in? Well, that's when you got to push your NHD provider and say, please tell me which one I'm in. They can do it for you very easily. And I think they will do it. Let's say they tell you you're in a high. Well, now you know the form is required. So you pull out the form and you got to fill it out before you give it to the buyer. The first thing you have to ask yourself is this house built before 2010? If it's built before 2010, the seller has to check the relevant boxes regarding fire hardening in paragraph 3 of this form. If the house is built after 2010, the seller does not have to check those boxes, but the form is still required. So the form is always required if you're in a high or very high, assuming a TDS is required. If you're exempt from the TDS because it's a probate, REO, bankruptcy, or trust sale, you're exempt from this form as well. But assuming it's 1 to 4, not exempt from the TDS, and it's in a high or very high, what that means, form is required. The first 2 paragraphs are just sort of information. The third one, the seller has to check the boxes if the house is built before 2010. All right, that takes care of fire hardening. Now, what about defensible space? In other words, fire hardening is just a disclosure. You're telling the buyer, hey, you might want to take steps to harden your home. And by the way, since my home was built before 2010, it wasn't built under the new fire building code. So therefore, I might have some features that are not as desirable as they could be. I may have a wood roof or something like that. You got to disclose it. You don't have to fix it. Buyer says, oh, I don't like your wood roof. I want you to change the roof. You don't have to do it. You're just telling them. But then we come to paragraph 4, defensible space. Do you know every one of us who's in a house that's in a high or very high fire zone, we are supposed to have 100 foot of defensible space right now. It's not a new law. You're supposed to have 100 feet of defensible space. And if you don't, CAL FIRE, if you're in a state responsibility area, or your local fire company can come out to your house today, check you out. And if you're not in compliance, they can, usually they give you time to fix it. But the point is they can require you to come into compliance. That's not new. What this new form does and what this new law does, it requires people to be proactive and actually reach out to the government, to the fire company, to come and inspect to see if you're in compliance. So we're all supposed to be in compliance anyway. But now this is requiring somebody to reach out and do it. Okay. So that's why we got paragraph 4B, and there are 4 choices. This is where it gets a little confusing. So the listing agent, you have to decide, do I check the box in B2, B3, B4, or do I not check any boxes and default to B1? You know what? Most of the time, 99% of the time, I think you're probably going to default to one. Because here's the thing. If there's, people have been saying, CAL FIRE has been saying, and now they finally took it back. They've been saying, oh, this new law requires the seller. Every time you sell a house in a high or very high fire zone, the seller is required to get a defensible space inspection before close of escrow. That is false. That is completely false. The only time a seller is required to get a defensible space inspection is if you live in a local city or a local fire district that has a requirement like that. And we have found very few places that require that. I think Truckee does. But in your counties, we haven't really, I mean, maybe there's isolated fire districts that you might know of, but there's no state law that requires any seller to get a defensible space inspection in order to sell their house. Like I said, there's a few local districts, but I don't think there are very many. I know they're not very many. In fact, I don't think there's a single one in Southern California. There may be some in Placer County. I think there may be some in Marin County, but not many, if any. Okay. So, and you would know that by now. You would know, the seller would know, because they, you know, or if you don't know for sure, just call up your local fire company. Say, is there any mandate here that I got to do an inspection in order to sell my house? Unless you're in Truckee or a couple other places, they're going to say they might not even know what you're talking about. Okay. All right. So assuming that there's no mandate for either the seller or the buyer to do something triggered by a sale, you're definitely not going to check paragraph 4B4 or 4B3 on this form. So now it's going to come down to paragraph 4B2 or 4B1. 4B2 says there's no local ordinance requiring obtaining documentation of compliance, but if the seller for some reason has in the last 6 months gotten some type of defensible space inspection and got some documentation, they'll give it to the buyer. So let me go through your checklist as a listing agent. First thing, you figure out if you're in a high or very high fire zone. If yes, you pull out the form. Second thing you ask yourself is this house built before or after 2010? If it's built before, I'm going to have the seller check the boxes in paragraph 3B. The third question I'm going to ask myself is, do we have a local ordinance here that requires a point of sale defensible space inspection? How do you want to know for sure? You call up your local fire company. Chances are they might not even know what you're talking about. All right. The fourth thing you're going to ask yourself is, hey, seller, in the last 6 months, has any government fire company been out to your property to see if you have defensible space? By the way, if you live in Big Bear, they come out every 6 months automatically. There's a couple other places where local fire companies or CAL FIRE, they come out automatically. So in those areas, the seller's always going to say, yeah, they were here 3 months ago, and they said I'm okay. You're going to say, great, let's check the box in 4B2 and let's give that paperwork to the buyer. But let's say the seller says, nope, I have not had a defensible space inspection in the last 6 months. So you've established there's no ordinance, local ordinance requiring you to do it. You've established that the seller has not obtained their own defensible space inspection in the last 6 months. That means you don't check any of the boxes on paragraph 4B of this form. You default to paragraph 4B1, which, if you haven't noticed it, you know what it says? It says the buyer is agreeing within a year after close, they are going to reach out and get documentation of compliance. Who are they going to reach out to? If they're in a state responsibility area, they're going to call CAL FIRE. If they're in a local fire responsibility area, they're going to call their local fire company. First question the buyer is going to have is, how do I know if I'm in a state or a local fire responsibility area? It's very easy to find out. You call up your local CAL FIRE office. Say, I just bought a house. Within the next year, I'm required to obtain documentation of compliance with defensible space. Can you come out and inspect CAL FIRE? And CAL FIRE is going to say, sure, if you're in a state area. If not, they're going to say, sorry, we don't have jurisdiction. Now you're going to call your local company. Say, hey, I just bought a house. I'm supposed to call you up to arrange some type of inspection so I can get documentation of compliance. You know what may happen? You know what probably will happen? You know what we've learned has been happening? You call up the local company and they say, we're too busy for that. We're not going to do that. We only respond to complaints, or we do random audits. In that case, buyer, you're done. You're completely done. You tried, you made your effort, you're done, nothing you have to do. I know what you're thinking. Some buyers are going to buy the house, sign the form, and then they're not going to call anybody in the next year to arrange some type of inspection. That's not your problem. It's not the seller's problem. It's not the realtor's problem. I don't even think the CAL FIRE or the local fire companies are going to be checking and keeping track of everybody who bought a house in the last year. This is almost like the honor system. You know what I think? If I bought a house, I would want to know if I had proper defensible space because I want to be safe in a fire. But anyway, that's the deal. Okay, that's the form. That's the rule. As I said, the confusing thing is CAL FIRE was saying, and now I'm still running into local fire companies who think this law requires the seller to do some type of inspection before close of escrow. That is not the case. That's not true. Okay, 99% of the time, it's the buyer, by signing this form, is assuming the responsibility themselves. Okay. Jody's asking me, if you remove all your contingencies, do you still get a 5-day right to cancel? Yes. Remember, buyers have 2 ways to get out of a deal. Number 1, they still have their contingencies. But number 2, even if you don't have contingencies anymore, these 5 forms that I mentioned give the buyer a 5-day right to cancel. The 4 we always had up until now: TDS, NHD, lead paint, and the SPQ. And now we have a 5th one that gives, that's why you want to give these forms to the buyer early. Give them to the, by the way, delivery to the buyer's agent is considered delivery to the buyer. Once you deliver them, that's the buyer's on the clock for 5 days. By the way, what if you give them this form and, you know, they don't even bother getting an inspection? They don't have to. Just by giving them the form for the next 5 days, they can walk. Just like with the TDS. You give them the TDS, even if there's nothing bad on the TDS, you get a 5-day right to cancel. Okay? All right. That's probably the most significant law that happened this year up until now. The other good one I think you're all aware of is Prop 19. Remember, if you're over 55 or severely disabled or the victim of a wildfire, you can take your house that you've owned a long time with a low property tax basis under Prop 13, sell that house and buy a new house anywhere in California and move there and take your low property tax with you to the new house. You can move anywhere in California. You can do it 3 times in your life, even if you've already done it once before under Prop 60. And you can even buy a more expensive house. You can buy a more expensive house and still transfer your property tax with a slight adjustment. Let's say you bought your house a long time ago for $200. It's now worth $800. You sell it for $800. You buy another one for $900. What's your property tax going to be on the $900,000 house you just bought? It's going to be that original $200 plus $100. The difference in the purchase price of the new one compared to the sale price of the old one, total of $300. If the new house costs less than the old house, you transfer the exact same 200,000 basis. Okay. All right. Let's talk about, before I go on, Brian had a question still about rentals. When I talk about evicting a tenant, yeah, I'm talking about evicting a tenant for a couple things. If they're on a lease, obviously you can't evict them until the lease is over unless they do something bad. After the lease expires, though, Now, single family home, you can just tell them to leave. You don't have to give them any notice. See, under the eviction moratorium, if the lease ended, you still couldn't kick them out. And you couldn't kick them out during the lease if they didn't pay rent because of COVID. Now, single family home, if they're on a lease, you can evict them. You don't need a reason once the lease is over. During the lease, you can evict them if they do something bad. Don't let you show, nuisance, criminal activity, waste, don't pay the rent, etc. Subtenants without permission. But if you have no particular reason that they did anything bad, you got to wait till the end of the lease. But that's the way it was before COVID too. Okay. All right. Glenn, buyer makes an offer and they removed all their contingencies in the offer, but they removed the contingencies before getting the forms. 3 days after the offer accepted, they get the forms. You're right. They have 5 days to cancel, not based on contingent. Okay, unfortunately, this is getting complicated here. You're right. Normally, when you give someone a contingency, you give a disclosure, not only do they have a 5-day statutory right of rescission, they also have the contingency. My offer is contingent on reviewing the disclosures, but I don't have to remove those contingencies until at least 5 days after you give them to me. But Glenn, your question is they removed the contingencies already before they even got the forms. They didn't have to do that, but they did. Since they removed the contingency, they no longer have the 5-day contingency extension, but they still have the statutory 5-day right to cancel. So you don't need another contingency removal form. The contingencies are gone in your scenario. It's just simply a question of the 5-day statutory. And by the way, some of you are thinking, I thought it was 3 to 5 days. You're right. If you deliver the disclosures in person, it's 3 days right to cancel. If you mail it or email it, it's 5. I don't think anybody does it in person. Okay. All right. Let's now talk about new laws the governor just signed. The biggest one, I think, is SB 9. You've probably heard about this. SB 9 says, if you live in a single family lot, R1 zoning, single family lot, you got a home there, you can now turn that home into a duplex. Now, duplex, I don't mean it has to be attached. It could be attached or it could be separate. I mean, it's not automatic, but they pretty much have to allow, the local city or county has to allow it as long as you meet the building code and basic, I mean, the city or county can have basic design standards for this or basic building rules for this, but basically they can't have a hearing and say no, they can't, you don't have to do an environmental impact report or anything like that. Basically, you can go ahead and turn your single family into 2 properties. Now, there are exceptions. This can only be done in urbanized areas as defined by the US Census Bureau. I don't know if all you guys are in urbanized areas or not. Second, can't do it on farmland, property designated for habitat protection, property designated for conservation. You can't do it if the property has been used as a rental at any time in the last 3 years. You can't do it if the property contains rent control property. But basically, if you don't come into those, and you can't do it in a fire zone unless they've taken the fire mitigation steps. You can't do it in an earthquake zone unless they've taken the earthquake mitigation steps. But assuming you don't have those exceptions, you can pretty much apply and get automatically, basically turn your one house into 2, okay? But there's more. In addition to that, or separate from that, you can do a lot split. Take a residential property and just split it. And then theoretically, you could put a duplex on each one, which you could turn one house into 4. But there are restrictions on the lot split. To do a lot split, the owner of the property doing the lot split has to sign an affidavit swearing they're going to live in one of the units for at least 3 years from the date of the lot split. Also, the 2 lots have to be roughly equal in size. Neither one can be more than 60% the size of the previous one. If there was any rentals on the property the last 3 years, can't do it. If there was any rent control, can't do it. If there was an Ellis Act eviction the last 15 years, can't do it. The lot has to be at least 2,400 square feet. And if the lot we're talking about was itself created by a lot split, you can't do it. And if the owner who's trying to do the lot split previously did a lot split on an adjacent property, you can't do it. And this doesn't supersede the Coastal Commission, the Coastal Act. So there are restrictions. But assuming you meet all of those criteria, sign the affidavit, not a rental, 2,400 square feet at least, hasn't been done before, no, this owner didn't do it on adjacent properties, meets the county's reasonable objective design standards and building standards, then you can then you can do it, okay? Now, you know what, one thing I like to point out is it's not as dramatic as it sounds though. Well, turning one house into 4 is pretty significant, right? Did you know right now, it's pretty easy to turn, even before this law, it's pretty easy to do one house into 3. Do you know it's almost automatic approval now on accessory dwelling units? You can almost always build a separate so-called granny flat in the backyard. You know, as long as it has a 4-foot setback and it's no more than 16 feet high, you can pretty much do it automatically. Plus, you can almost automatically convert your garage or convert any other space. It's hard to disapprove those, which means right now I could take my house and probably turn it into 3 at least, right? Change out my garage and do that. Does that mean then on this new law, I take my property, I do a lot split, I put a duplex on each one. Can I now add an accessory dwelling unit to each of those? No. The law is very clear. If you're going to build units pursuant to SB 9, you cannot add any ADUs. Donna has asked the great question. Believe it or not, Donna, the law didn't address the question of, does this supersede HOAs? Does this supersede CC&Rs? The answer is it was not determined. So that needs to be figured out. The possibilities are, they have to clarify the law. One possible clarification could be that this law establishes California state policy. And if this becomes California public policy, CC&Rs that violate California public policy are not enforceable. But that's not what the law says yet. So that's an interesting question. We don't know yet if this is going to supersede HOAs. Matt asked the question, if the intent is to increase housing, why are areas within rent control areas excluded? They want to increase housing, but they don't want to decrease rental properties, rentals. I think that's sort of the thinking on that one, okay? All right, so that's SB 9. SB 10, you might have heard about, slightly different. So SB 9, what I just told you about, is a state mandate overruling locals. SB 10 does not overrule locals. SB 10 just empowers local governments if you're in a so-called transit-rich area or urban infill. Transit-rich areas within a certain distance from a major bus station, half a mile within a bus station, train station, ferry station, or an intersection of 2 bus lines where they stop at least once every 15 minutes. Anyway, if you fit into that category, cities and counties, if they want to, can now accelerate approvals for apartment buildings up to 10 units in that area, okay? But this clearly cannot be done in a fire zone, can't be done if it involves demolishing any rent control property, can't be done in a historic district, and this clearly is not superseded by HOA. So an HOA could prevent this from happening. And remember, this is not a state mandate. This is just empowering locals to do it if they want to, okay? Those are probably the two most significant new laws that the governor just signed. Are there any others that you might be interested in that affect you as realtors? A couple of them. For one thing, when you renew your license the next time, there's going to be a required class. First of all, if you get a license for the first time, there's a new 2-hour class on implicit bias. If you renew your license, the first renewal, there's also going to be a 2-hour class. And if you're beyond your first renewal, the 8-hour survey class is now going to be a 9-hour survey class. There's going to be an extra hour about implicit bias. You know, the concept here is we're all biased, and whether we know it or not, subconsciously, it's just a question of being able to recognize it, how to address it, and be aware that when we're talking about bias in California, that means when you make housing decisions, you can't make your decision to sell or rent based on someone's being a member of a protected class. And California has 22 protected classes. Some of it some people don't even aware of, like marital status. You can't discriminate against someone because they're married or not married. Family status. You can't discriminate against someone based on whether they have kids or don't have kids. Military status. You can't discriminate against people for or against based on military status. I know what you're thinking. Why would some people discriminate against them? Some people do actually discriminate against people, especially in rental properties. Anyway, you all got that form. It's attached to your contract, the Fair Housing Advisory. But the point is, there's going to be a new class on that you're going to take when you renew your license. I hate to tell you, but there's going to be another new form. Okay, it's regarding bias in fair housing. It's called the Appraisal Disclosure Notice. So remember I said we now have the big 5 disclosure forms, and then we also have the little ones. Well, this is another one, but this is going to be attached to the purchase contract. You know how the privacy notice is now attached to the purchase contract? That's a required form. But instead of turning that into a disclosure form, we just attached it to the purchase contract. Same thing. There's going to be, starting next year, actually starting next July, there's going to be an appraisal disclosure notice. That's basically just telling the buyer and the seller, appraisals must be unbiased, objective, not influenced by improper considerations, all these categories that we're all familiar with. And this new form is going to tell the buyer and seller how to file a complaint about an appraisal. If they think the appraisal was biased, it's going to tell them right on this form how to file a complaint. And have you been reading about this? There have actually been surveys, though, where appraisals have testers out there, and they've actually shown that appraisals sometimes do vary in the appraised value based on who the buyers are, their personal characteristics. So it's not like they're making this stuff up. There's actually some data to support. The point is, right now when you have the purchase contract, there are 6 attachments. Have you noticed that? The 2 agency forms, the fair housing, the wire fraud advisory, the inspection advisory, and the privacy notice. Well, next July, there's going to be a 7th form attached. It's going to be this appraisal disclosure notice. Okay. So it's going to happen without you even noticing it, because it's going to be attached. Okay. One more on fair housing you should know about. You occasionally run into restrictive covenants that are illegal. I mean, some restrictive covenants are okay. In other words, there's something attached to a deed. This property has to be used for the purpose of a school or something like that, whatever, or a church or something like that. But sometimes you'll come across these restrictive covenants that are illegal. It says this property can only be sold to Caucasian people. They're still around. They haven't been enforceable since 1948, but they're still there. And it still bothers people. It offends people when they come across one on their property and they want to get it removed. Well, right now, the process is you got to go file a form, pay a fee. The county council has to review it. They take a long time. It's a cumbersome process. There's a new law that says next year or next July, in order to do this, you won't have to pay a fee. The county council will have to give you a decision within 3 months, whether it's actually an unlawful restrictive covenant. So the whole process to do it will be simpler, and there'll be a new form to do it. Second thing that affects you is, listen to this. I don't know if it will affect you, but it says any realtor, title company, or escrow company who happens to be aware when they're working on a sale that there is a restrictive covenant attached to this deed. I don't think you necessarily are going to know that. You probably don't. But if for some, title or escrow probably will come across it. If anyone, realtor, title, or escrow, or the recorder's office is aware of it, they're going to have to notify the buyer and say, hey, there's a restrictive covenant here, and there's a new process where you can basically get it removed. But the third thing I think is actually the most significant is the recording offices themselves are going to be, it's going to take them a while, obviously. Recording offices themselves are going to be required to go through all of their deeds in their jurisdiction. And if they find any of these unlawful restrictive covenants, the recorder's office is going to have to remove it themselves. Obviously, that's going to take care of the problem. But the point is there's a lot of them, and it's going to take them a time, and they don't really have a time deadline in this law. So in the meantime, what's changed is title, escrow, realtors, and recorder's office have to inform the buyer if they happen to have knowledge that there is a suspected, a probably unlawful restrictive covenant. And second, once this becomes aware, the owner of the property or the buyer is going to have a streamlined process to get it removed quickly, as opposed to waiting for the recording office to do it, if you're following what I'm saying there. Okay, almost done here. Another law, interesting, related to fair housing. Do you know there's some buildings where a certain number of the units in the buildings are set aside for affordable units? You know, there's some market rate, some affordable. Do you know in some of these buildings, they have it broken down that the market rate people get this swimming pool and the affordable units get this swimming pool, and yet the market people can use this door, other people have to use this door. Anyway, that's all going away January 1st. If you have a building of residential property where there's affordable units and market units, everyone has the same access to everything. Okay? Which probably makes sense. A couple more things. There's been a slight beefing up of the penalties regarding animals, emotional support animals. Let's say you are a landlord, right? And a tenant shows up with an animal, and you say, I'm so sorry, this is a no pet building. Now what? Well, if it's a pet, you can just simply say no. But what if the tenant says, this is not a pet? Well, what is it? Looks like a pet. He said, no, it's a service dog. If it's a service animal, it's got to be a dog or a miniature horse. And if it is, you can only ask the person 2 questions. Number 1, are you disabled? Number 2, what task has that dog been trained to do? You can't ask them what their disability is. You can't ask them for proof that they're disabled. Obviously, by the way, if they're in a wheelchair or something, don't even ask them, okay? But you can ask them the question, and then they got to, and even though they don't have to tell you what the disability is, they have to tell you what the dog has been trained to do, which probably tells you what the disability is. But you're not entitled to proof that the dog has been trained. If they say they're disabled and they say the dog has been trained to help me move or help me respond to the phone call or whatever, you're done. You got to rent to them. But what if they show up with something not a dog, or they show up with a dog, but it's not trained? In other words, it's not a service. What if they say this isn't, if they say it's a service animal, it's got to be a dog, and you can ask those two questions. But if they show up with an emotional, they show up with an animal, maybe it's not a dog, or maybe it is a dog, and you say, I'm sorry, no pets, and they say, no, 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 this is an emotional support animal. Now what? Well, now you are entitled to proof that they need the animal. Their word is not good enough. You're entitled to something in writing from someone who's been taking care of this person, and this person has to give you something in writing saying, based on my personal contact with this person, I believe they have a disability and they need an emotional support animal. Okay, you know what the problem out there is? There have been criminals out there providing these certificates without having any contact with this person. And they're also providing these misleading certificates that are telling the people that since you have an emotional support animal, it's like a service animal. You know what the real difference is? If you have a service animal, service dog, you cannot be denied entrance into a store or a restaurant. If it's an emotional support animal, you can be denied entrance to a store or restaurant. You just can't be denied to rent property. However, there's a new law that requires the person providing the emotional support certificate to send a notice to the person. In other words, they're giving, maybe it's a doctor or something, they're giving a certificate to the person. They got to give a disclosure to this person saying, by the way, this is an emotional support animal. It's not a service animal. You don't have the same rights as a service animal. And also, anyone who claims that they are legitimately entitled to a service, an emotional support animal, and do not have the documentation, is committing a criminal act. So maybe people are going to think twice about pretending that it's an emotional support animal, and people are going to think twice about providing this documentation to someone, because they're going to be running the risk of a criminal offense if they're in violation. Plus, there's a disclosure that must be given to the person with the emotional support animal, telling them, number one, this animal has not been trained, and number two, this animal does not have the rights of a service animal. So then this person, you're entitled, you, the landlord, are entitled to see this notice, which is going to say this. So everyone's going to understand this is an emotional support animal. It's not a service dog. And if you're lying about this, it's a criminal offense. However, having said that, assuming that you did get this notice, you now have to rent to this person. Yes, it depends. Now you have to ask yourself, is this a reasonable emotional support animal? Let's say the emotional support animal is a gorilla. You can say no to that. It's a peacock. You can say no to that. It's a 300-pound dog and it's a 500 square foot unit. You can say no, that's not reasonable. So you can still have a reasonable objection. But assuming they get the documentation and it's a nice little dog or cat or something, you really have no basis to say it's not reasonable, then you have to allow it. The big change is there's penalties now, severe penalties against people who provide, there's a notice requirement that the provider of the documentation has to give to the person with the animal. And it also warns the person that they could have severe consequences if they're not telling the truth. Okay, so I don't know if that's going to change anything. It also says if it's a medical provider providing this notice, this medical provider must have had a clinical evaluation of this person. It's not like they just met on the internet. They had to actually have a clinical evaluation of this person. It could be a virtual examination, I admit that. But anyway, that's the latest on that. Anything else that's really changed that you're really going to need to know about next year? I think that's about it. I got one bit of news that might help you. Let's say you get your real estate license when you're single or you're married, and then you get married or you're single, so your name changes. So you want to change your real estate license, and now you have a different surname than you had before. There's a new law effective January 1st that says, regardless of the actual name on your current license, if you got your license originally with a previous last name, you can continue to use that previous surname in your advertising. So you can sort of use either name. The last name when you originally got your license, and the last name that you changed it to because you got married or divorced, or you just wanted to change your name, whatever. Okay. Donna, of course, you want to know about the new RPA. First of all, Patrick, what about insurance restrictions? Well, insurance companies are bound by the same fair housing laws that everybody else is. So insurance companies can have a reasonable thing, like, oh yeah, we don't allow certain types of animals, like the gorilla. They can say no gorillas. I mean, but an insurance company can't be more restrictive than a landlord can be, as far as, in other words, you can have you have to reasonably accommodate the person and the animal. And who decides what's reasonable? Judges decide what's reasonable, okay? The new RPA, you notice I haven't talked about that yet, and I'm not really going to talk about it today. So up until now, there haven't been a lot of new forms this year. Remember that fair housing advisory came out in the spring, and that's attached to all your forms. And you remember this fire hardening defensible space form? I talked about that came out. And there's another form that came out that you don't have to use called the transfer of listing, TOL. You want to transfer a listing? You don't have to transfer a listing, but let's say an agent's coming to your office and their broker is allowing that agent to bring their current listing over to your office. We have a nice form now to document that. Okay. But at the end of the year, in December, we're going to have a significant form change. The purchase contract that you know and love is going to change fairly significantly. And to talk about it, it really requires a 4-hour class, which I hope you'll all maybe sign up to take before the end of the year. Or in case you missed it, we started yesterday to do we're doing every Monday at 11 o'clock, a free 1-hour webinar. And each webinar is going to talk about like a couple pages of the form. If you missed the one yesterday, it's recorded. It's on the C.A.R. website. Every Monday, you can do that. So the big picture is the purchase contract is going to go from 10 pages to 16. Now you're going to think there must be a whole lot of new stuff. And the answer is yes and no. Pretty much all the paragraphs that you're familiar with are still there. They've just been expanded with more language to protect the realtor, protect the seller, more explanations, more good stuff. That explains about 3 of the extra pages. Then the only other new thing in the form is that all of the deal points that you negotiate on, like price, how long of an escrow, when are we going to open escrow, how long to remove the contingencies, all the who's paying for this and how long and who is it and how much, all of those blanks have been grouped together in one place in paragraph 3. There's a new grid where you have all the negotiating points. They're still going to have all the individual paragraphs explaining everything, but actually filling in the blank, who's going to pay for this, how much is it, what's the deadline, you'll see that's all going to be in one place. Jennifer, it's 11 o'clock on Mondays. And Patrick, I think you're right. There isn't going to be one this upcoming Monday. And Patrick, yes, you're right. Some insurance companies can deny specific breeds. And I don't think they've been challenged on that. So in other words, if your insurance company will not insure a particular type of animal, you, the landlord, are being reasonable by saying to the tenant, I'm sorry, I don't have insurance coverage here, therefore I can't do it. You know what some judges have said though? Some judges have said, well, landlord, have you tried other insurance companies to see if they insure this particular breed? In other words, you got to work with these tenants. You got to see what, I mean, to be really safe, you try it a couple more insurance companies to see. Yeah, oh, this insurance company will insure it, but it's going to increase my premium by $500. You don't have to do that. But the point is, there have actually been cases where if you can find a different insurance company who's not going to charge you anymore, and they will, maybe you should do that. I mean, it's a case-by-case basis, okay? If you have any questions on that, please call us. Okay. I think I've given you enough. You probably have a headache already from all this stuff. It's always changing. What the good news is, remember, of course, we don't have to worry about COVID anymore when you're showing houses with one rule. Remember, there are actually two things you still got to remember. Number one, I don't know if this is being enforced, but if you're at an open house or you're at a showing and you are not vaccinated, you're supposed to be wearing a mask. It's the honor system. Sellers don't have to check with, no one has to check anybody, but it is the honor system. If you are unvaccinated and you're in an open house or a showing, you should be wearing a mask. And by the way, sellers, if they want to, or real estate brokers, if they want to, it's your house, it's your office. You could be stricter. You could say, I want everyone wearing a mask. I don't care about your vaccination status. Or the seller could say, I want proof of your vaccination status. They can do that if they want to. They don't have to, but they can. Assuming they're not doing that, the rule is that unvaccinated people going into open houses or showing should be wearing masks. Finally, this is common sense, but I think you all probably know this. We still have the basic rule that if I am showing a house or I'm at an open house and somebody's there, and then they tell me the next day, oh, I was at your house yesterday and guess what? I just tested positive for COVID today. You have to think back and say, okay, I was there with that person in my office or that showing. Let's see, was there anybody there who was within 6 feet of this person for at least 15 minutes? If so, you have to make a good faith effort to contact any person who was in that type of close proximity to the person who you now know was probably had COVID when they were in that proximity. That's a general law. That's not written down. That's not a real estate law. That's just general. If you want to avoid getting sued in general, you have to disclose if you're aware in a business setting that someone was in close proximity for at least 15 minutes with someone who you now know was positive. And usually it's considered a 10-day period of contagiousness. Okay. All right. Any more questions? You can even unmute yourself if you want, or put it in chat.
Anybody have any questions?
Probably everyone's hungry for lunch right now.
Let's see. Nope.
Donna's asking me, am I doing an RPA class? Is that what you're asking, Donna? I'm doing a lot of classes. I'm doing one on.
We had an RPA class. We will be scheduling another one probably next month, beginning of December.
And Friday, I'm doing one open to everybody on the C.A.R. website.
I did go to that RPA class that we had through the Delta, but it was kind of generic for people who there were a lot of questions that were asked, people who were not practicing real estate on a regular basis. So it was kind of a lot of wasted time as far as
was it one of our classes or somebody else's class?
It was the one through DAR.
It was a C.A.R. class.
Okay, yeah, you're right. I mean, you never can tell what kind of questions you get, but anyway, we're going to keep doing them. Patty, did you have a question you wanted to say?
I do. I'm just unclear on this. So I had a tenant not paying, and so we applied for the rent release, got approved for like $15,000, but by the time I got approved, now he owes us $19,000. So can I reapply, or what happens in that incident?
Okay, so yeah, unfortunately, the question is, are you trying to evict? Are you trying to sue, or what? I mean, if you're trying to evict, to do the unlawful detainer, you're gonna have to demonstrate that you did apply. And even though you applied, you got 15, he now owes you 4 more. In order to evict this person in the next 6 months, if you want to evict him in the next 6 months, you're gonna have to prove that you applied again for the extra money that he owed.
So you can't apply twice, is I guess my question.
Yeah, yeah. It's unfortunate, that's a real pain, but unfortunately, that's the way it is for the next 6 months.
So if it takes them 2 or 3 months to get back to you with
So
an
in other
answer,
words,
you're still,
well,
It's-
I mean, maybe you just want to start the eviction process with this tenant now. Right? And in other words, maybe hire an eviction lawyer or something, just start the process, get it going. Because you're right, if you keep going back and forth applying, he doesn't pay, you apply for rental assistance, takes a long time, and he keeps not paying. Depends on what you really want. Do you want him out as soon as possible? Then I would start the eviction process right. I'd probably get a lawyer to do it, and I'd start the eviction process right now and just get the ball rolling, because you don't have to wait indefinitely to get the response.
okay, thank you.
You're welcome. Anybody else? Peggy, who would enforce emotional support pet forgery? Yes, the police. Call the cops. It's a criminal offense. I don't know if they're going to think it's a good use of their time, but nevertheless, it's a criminal matter, right? Monica says Patty has an excellent referral for an eviction attorney. Patrick, thank you. Yes, you can keep applying. I've been told you can apply till the money runs out. But you're right. There's probably a limit on that. And some places have more money than others, but you can apply for rental assistance. But you can evict right now for non-payment. Give them the right 3-day notice, start the process. At the same time, apply for the rental assistance if they're still not paying. But you never know. You may get a judge to accelerate the process. So you don't have to wait to start the process, is what I'm really saying. Okay. You're welcome, everyone.
Thank you, Gov.
All right. We'll see you in person one of these days, I hope.